Welcome to Advisory Opinions. I'm Sarah Isgur. That's David French. And we have I think it'll be a really fun episode. We're going to talk about the Supreme Court's argument in Chiles v. Salazar. That was the conversion therapy case. We're going to talk also about the National Guard heading to Portland, or not, as it turns out. A judge recently enjoined that. And finally, Sarah, state courts don't suck. All that and more on Advisory Opinions. All right, David, this is going to be like the platonic ideal of an Advisory Opinions podcast. We're back in oral argument season. We have expert emails from our listeners. But before we dive in, have you memorized the new Taylor Swift album? Have you already ranked all of the songs? How are you doing?
I have listened to one song, the one that you mentioned on a text thread, Ophelia. Because what'd you say, that it slaps? What I can't remember.
I think I said it's a real bop.
It's a bop. Okay, so anytime something slaps or is a bop, I'm there. Like that's just where I'm drawn to that, like a moth towards flame. And it was good. It was fine. I'm not a Swiftie, although there are a lot of Taylor Swift songs that I like. But let's just say I'm not waiting with bated breath for the drop of the next Taylor Swift album like I am the next Rings of Power season. These are different categories for me.
Gender differences. By the way, if you have not already subscribed to the new SCOTUS blog newsletter, they just started it a couple weeks ago, and already it is morphing into this very fun thing. So they have now SCOTUS quote. And the quote today was from William Rehnquist in 1976. Now, he's an associate justice in 1976, and he's just joined the court. And here was the quote. The Chief Justice presides over a conference, not of 8 subordinates, whom he may direct or instruct, but of 8 associates who, like him, have tenure during good behavior and who are as independent as hogs on ice.
Independent as hogs on ice.
Pretty good, right? And he's saying that as one of the hogs.
Yeah. I don't consider hogs on ice as a sort of a grand sign of independence. I would think of it more as like haplessness or, yeah, that's funny.
Yeah, nevertheless, charming. All right. We had the conversion therapy argument on Tuesday. And David, are we just getting spoiled? Are we on like the hedonic treadmill of Supreme Court dockets? Because all of a sudden, some of these merits docket cases are just feeling dull, predictable. I don't know. Yawn.
Well, it's a sign of how much the culture war is changing. I mean, let's look at the conversion therapy case is a case that, 3 years ago, 4 years ago, I mean, maybe even more recently, would have been the subject of a ton of coverage. This would have been forecast as, okay, if the Christian counselor loses, and just to set up this case, the question is, can a Christian counselor engage in so-called conversion therapy, defined not just as the desire as a therapy with the aim of changing a person's sexual orientation or gender identity, but also broad enough to encompass asking or counseling towards changes in behavior, in other words, that are related to sexual orientation or gender identity. And so very broad statute. You would have an enormous number of sort of competing wild claims like LGBT youth are under direct threat, or religious freedom is on the verge of extinction. And you would have sort of this big buildup. And then, it would be covered breathlessly in the papers. You would have a detailed argument analysis, a series of op-eds running down the opinion columns. And I got up this morning and I was looking for the day after commentary. Crickets.
Not here on
nothing.
Advisory Opinions, though. So let's.
Yeah, I mean, it's just wild. I mean, is this not? Let's just pause on this a minute. What a symbol of how public discourse has changed.
Totally.
It's really remarkable.
And I mean, again, I literally feel it. But we here on Advisory Opinions are absolutely going to break down this argument. David, let's start at the end, if you will.
Yeah.
Did you feel like you had a prediction coming out? Did you learn where the justices were based on this argument?
I mean, I think the prediction, I have a pretty solid prediction and a tentative prediction. And the
Ooh,
solid prediction is that the conversion therapy, that the 10th Circuit is going to be reversed.
yeah.
Um, the 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 less solid prediction is, will it be sent back for a strict scrutiny analysis, or will the Supreme Court just go ahead and do the strict scrutiny analysis? So that's the big question for me. So I think it'll be reversed. And I think that the framework for reviewing the Colorado statute is going to be strict scrutiny. I think they're going to look at this as far more like a conversation than medication. So medication, and if you put it in the counseling context, some of these aversion type therapies that are awful, horrible, like compelling people to vomit or shock therapy, like that would not be encompassed in the term talk therapy. And as was made clear in the oral argument, the state could absolutely regulate that stuff, absolutely ban that stuff. The question here really is on that talk therapy point. And so I think they're going to say, look, that's protected by the First Amendment. Calling it licensing doesn't remove it from the First Amendment. Calling it treatment doesn't remove it from the First Amendment. So it's going to be First Amendment protected, and it's going to be subject to strict scrutiny. And the only question that I have is, does it go back to the 10th Circuit? That's my main, that's my bottom line assessment.
Okay, I think this is 9-0, reversing the 10th Circuit.
Mm-hmm.
I counted to 4 votes to send it back down.
Yeah.
And have the the lower courts first apply strict scrutiny. And we didn't hear anything from Justice Kavanaugh. So your critical 5th vote, the swingiest vote on the court, we didn't hear any questions from. So as you say, David, there's almost like no way to know based on that. But let's now dive into some of the details. So Colorado's Minor Protection Act, which there's a similar law, 25 different states, passed on bipartisan basis oftentimes. This is not a pure Republican versus Democrat law. Bans therapy for the purpose of changing a minor's sexual orientation or gender identity. So, according to Colorado, if you don't want to change their sexual orientation, you can say whatever you want. And if you're not a licensed therapist, you can say whatever you want. And if it's an adult and you are a licensed therapist, you can say whatever you want. So their argument was, this is really narrow. It's minors with a licensed therapist where they're actually telling the person that they will be able to change their sexual orientation, which we, Colorado, don't think is possible. Gender identity as well, sexual orientation and gender identity. Okay, so now we have Chiles, who I called Chili last time. I've been watching too much Bluey, I guess. Sorry, Miss Chiles. Okay. She wishes to help clients who voluntarily come with the desire to change their behaviors, expressions, attractions, and identity. Okay, so this is really important because Colorado also argued that she didn't have standing because the law didn't apply to her. And there's this whole back and forth. And then you get to Gorsuch saying, I don't know, she says that they have the desire to change their identity and attractions. That seems like to squarely fit into the law. And the guy's like, yeah, from Colorado. Sorry, the woman. And and then Sotomayor goes, well, that settles the standing question. Sotomayor, who had been very open to the standing problem. Anyway.
Yeah.
Okay, so that's what she wants to do. Seeking to reduce or eliminate unwanted sexual attractions or become more comfortable with their bodies. So she files a lawsuit in Colorado asking a federal court to block the state from enforcing the conversion therapy ban against her. And again, before it was ever enforced, right? So there is this little procedural question of like, does she need to wait until she gets a letter in the mail threatening her license or something else? She didn't. This was pre-enforcement challenge. Okay, so Colorado. This ban regulates one narrow medical treatment that carries a great risk of harm. It does not stop healthcare professionals from expressing a viewpoint to a patient or anyone else. States can't lose the power to regulate healthcare professionals just because those professionals are using words. So to break that down a little, they're calling this a treatment as opposed to a viewpoint, right? The treatment, quote unquote, is saying, we can change your sexual orientation. We can change how you feel about your gender identity through this conversation. What they're saying, that's banned. What's not banned, however, is saying, I think, gender dysphoria is BS. But anyway, now let's talk about your gender dysphoria, which honestly doesn't make a lot of sense, but sure.
Makes no sense, yeah.
Okay, so this is Chiles then. Chiles is lawyer. This prohibits all counseling conversations when a client seeks to change for any behavior, feeling, or identity connected with gender identity or sexual orientation. At the same time, it allows other people who are not licensed counselors to have the same conversation it bans for her, and even permits licensed counselors to have the same conversations with adults. Colorado's true aim, therefore, is to silence and marginalize views it dislikes by gagging the professionals best equipped to speak on these issues. If you, for instance, upheld this law, it would under the theory at least, states could prevent doctors from discussing birth control, could prevent counselors from encouraging or discouraging options like divorce. All right, so this is how the two sides lay out their arguments. I've got 3 justice questions, David, that I thought were the standouts. Jackson, Alito, and Sotomayor. And I'm going to go in order of difficulty, if you will.
Okay. Can I just make a remark about the statute real fast?
Yeah.
So one of the things that's really important when you're hearing about these things like a conversion therapy ban is that they're often explained in a very top line. A conversion therapy is designed to stop people from attempting to change your sexual orientation. Okay, so that sort of top line quick summary of it actually ends up being very misleading when you actually look at the language of the statute. So it will say any practice or treatment. It defines conversion therapy as any practice or treatment by licensee, registrant, or certificate holder that are attempts or purports to change an individual's sexual orientation or gender identity. Okay, that's the top line that you said that is reported widely. But then it goes, comma, including
right.
efforts to change behaviors or gender expressions or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. So this is not, you say it's a conversion therapy ban. It's sweeping beyond that. It's sweeping beyond that. I think that's very important to point out because a lot of times you hear conversion therapy ban and immediately a lot of people who are familiar with sort of the really dark history of some elements of this, it goes to electric shock. It goes to aversion therapy. It goes to things like rebirthing, like really bizarre, weird practices that have been engaged at that should be regulated, regulated into oblivion. But what we're talking about here is are conversations. These are conversations. These are not the other treatments. And the definition is a lot broader than that top line summary.
I also felt like Colorado kind of wasted everyone's time at this argument, and they were the ones who needed the time to win the case by pushing this standing question. I would say 20, maybe 25% of this argument was spent with Colorado saying this law didn't apply to Chiles, only to at the end agree that the law applied to Chiles. You guys were the ones who needed, who came in as the underdog, and yet you were the ones running time on the clock. That makes no sense as a strategic matter. And Gorsuch just, like, to mix sports metaphors, had them against the ropes on this and just delivering body blows to the exact point you just made, David, on the including language. Like, under what world of statutory interpretation could it possibly mean you must walk into the room saying, we will change your sexual orientation and only that, and as long as you don't use those magic words, then you're fine based on that statutory language. And then again, they're like, oh, it doesn't apply to her. It doesn't apply to her. And then at the end to say, yes, it does. And have Sotomayor say, we're done here. I mean, the law should be the law and it shouldn't matter whether you frustrate the justices. But why take the risk, Like, why go out of your way to frustrate Justice Sotomayor, who's been sort of trying to help you in this argument, only to have her throw up her hands when you give up the argument in the end. Okay, let me read Justice Jackson here. It's very odd that you could have two scenarios where you have two licensed professionals both attempting to provide treatment to an individual, say, for the same issue, that, the person says, I'd like to live consistently with my biological sex. I feel that I'm not doing that. I'd like your help. Medical professional A treats that condition with medication. Medical professional B treats that condition with talk therapy. And I guess under your theory, this is now to Chiles's lawyer, those two scenarios are sufficiently different from a constitutional perspective that one could be allowed and the other not. So this gets to the Scrimeti point, David.
Yes.
Why are you allowed to ban hormone treatment and you're
Right.
not allowed to ban this treatment on the other side? And I know the answer to that for a lot of people is like, that's a dumb question. The answer is the First Amendment. But I think if you're a normal non-lawyer, it's a little hard to say why. I mean, these are both licensed professionals. They're both purporting to do medicine. Why can the law reach one and not the other? Because boy, it sure seems like it's reaching something on one side of this issue and not the other.
Yeah, that's a really good question. A number of people have asked that question. And I think that, the answer is there is just an empirical substantial difference between a conversation and medication or surgery. There is a difference in nature, a difference in kind. And if you're talking about things as complex as sexuality, things as complex as gender identity, things as complex as how morality and religion intersect with sexuality and gender identity, what you're talking about are a lot of things that are outside the realm of empirical questions, such as in peer-reviewed blind research, does this drug achieve this result? And it is and with these potential physical side effects that could lead to problems with fertility or you name it. And and you don't eliminate the First Amendment by saying, well, no, we're not actually regulating speech, we're regulating treatment, or otherwise you've got a lot of regulated professions, whether it's therapists to lawyers to you name it, that all of a sudden by labeling it treatment or by labeling it legal advice as opposed to a viewpoint, that all of a sudden now you're outside the realm of First Amendment protected expression. And that strikes me as quite a stretch, also amplified by the fact, and I think this is a very, very important element. I think it was maybe Gorsuch who brought this up, that a lot of the regulation of these helping professions is not actually being done by impartial, dispassionate regulating entities. You're talking about entities that in many ways, for many years, have become hotbeds of activism. They possess their own viewpoints. They possess their own sometimes rather radical positions on political, social, cultural issues. And so there is a cost to looking at professional associations as a locus of activism. And then once your activism takes over a professional association, then is it still the same kind of professional association to which sort of this absolute deference is owed? And that's lurking in the background of this. I think quite clearly this is lurking in the background. And then there's another factor here that I think for years I would make this argument, Sarah, when talking about things like conversion therapy. I would say, look, guys, if you uphold a statute that restricts conversion therapy along these lines, I want to be very clear, along these pure talk therapy lines, not the lines of shock, aversion, all of these other things. But if you intervene in this viewpoint-oriented basis, what is to stop a series of states banning affirming therapy for LGBT youth? What's to stop that? And I think for a lot of years, a lot of folks on the left were like, I'll tell you what's to stop it is nobody's going to do that. Nobody's going to do that. We're the wave of the future. You're standing in the way. You free speechers, you're standing in the way of consensus, of progress, etc. And now I think it's abundantly clear to anyone paying attention that if you uphold a speech restriction, if you permit a speech restriction, the right will give it to you with prejudice. And so, okay, think that through, guys. Think that through. And so I wish we could win free speech arguments based on principle, but if you have to win them on pragmatism, that I know you don't care about their speech, but you do care about your speech, and the only way to protect your speech is to protect their speech. If that's the last line of defense for free speech, and it is, I think it's probably more effective now than it used to be.
Okay, I want to push back on one thing you said, though, comparing Scrimeti to this.
Mm-hmm.
Because you baked into the Scrimeti medical care case that they were concerned about the long-term effects of certain drugs when taken by minors. I want to change your hypothetical, or rather, I want to make it a hypothetical, whatever. In my new world that I've just created, a state passes a law banning gender-affirming care, medical care, hormones, surgeries, etc., for minors. And the stated reason is because gender dysphoria is a mental illness, and we're not going to affirm a mental illness. Instead, you need therapy. You don't need medical treatment for that. That itself is dangerous because you're affirming someone's mental illness. And then you have a state that's telling someone that they have a mental illness, and that you're not allowed to tell them that you must, help them come to terms with their immutable characteristic of having gender dysphoria. Why? The fact that one is done through talk therapy and one is done through medication, when both are based on viewpoints, does seem to bring those pretty close together, David. You see what I'm saying?
Yeah, I see what you're saying.
It's based on the viewpoint. I'm going to pick on Tennessee because it's just easier for us all to remember. Tennessee passes the law because of their viewpoint that it's a mental illness. But instead of it banning the talk therapy, they're banning the thing that people are doing to affirm the care, which is medical treatment. Those both feel like viewpoint discrimination.
I mean, I think you raise an interesting hypothetical, which is, to be clear, not the case.
It was not the case in Scrimeti.
It was not the case, yeah. Because the case in Scrimeti was essentially, these medications are not actually effective for the stated purpose.
And totally different, but it's not that hard to imagine that a state basically does a poor job passing the law.
Oh, for example, to move it a little bit from the medical treatment world, there's talk about passing laws banning transgender people from owning firearms or restricting transgender people from owning firearms on the basis that there's a state assessment that being transgender is a mental illness within the meaning, so severe that it should. And so you do see some of these movements in that direction to sort of classify, to categorize everybody in the transgender category.
But I feel like this is what Jackson was trying to get at. If your reasons are the same, basically you have animus on the left in Colorado, you have animus on the right in my hypothetical state, which again, I don't think is that hard to imagine. Why should those two be treated differently under the Constitution? And I hear your point that because the animus on the left is trying to control speech and the animus on the right is trying to control, a syringe. But that's a little, and I think that is the law, by the way. I'm not actually disagreeing with you. I think that is, but I don't think Jackson's point is as dumb as people thought either.
It's not remotely dumb. There's nothing dumb about it. I mean, your hypo is a very, very good hypo, to which the answer really does depend on the regulation of speech versus conduct.
Right.
And,
all right.
Yeah. And there's just greater state ability to regulate conduct than speech.
Let me read you Justice Alito now. Again, we're going to have the two licensed therapists. One, an adolescent male comes to a licensed therapist and says he's attracted to other males, but he feels uneasy and guilty with those feelings. He wants to end or lessen them, and he asks for the therapist's help in doing so. In the second situation, a similar adolescent male comes to a licensed therapist, says he's attracted to other males, feels uneasy and guilty about those feelings, and he wants the therapist's help so he will feel comfortable as a gay young man. It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants. And the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that's what he or she wants. Looks like blatant viewpoint discrimination. Yeah. Or, I mean, David, or is it the case that states can ban the other one, and so you just get to have the choice? Because, and this is the part that I think is difficult, that the court maybe didn't grapple with nearly as much as the standing question, for instance. If you're a licensed professional, think of this as like prior restraint. Like, this law is saying you can't engage in this conversation. And we're talking about that, and that's fine. But there's also penalties on the back end, right? There's malpractice lawsuits that you can bring. Yep. If a therapist basically promises you that you can change your sexual orientation, you can sue them afterward. Even if there's no harm, for instance, like, malpractice laws are pretty broad. But David, there's, on the prior restraint thing, there's also licensing. Isn't this a little bit weird that we're allowing the state to license people and tell them what the standard of care is, which is how you get your license and how you're going to bring a malpractice suit at the end? But like, we're fighting over this law? I mean, maybe it's good to fight over this law, but a lot of this conversation is what's the standard of care? And I couldn't help but thinking, like, yeah, but if the state gets to determine the standard of care, or if these experts do, and by the way, our history of the standard of care is a hot mess, you know.
Oh, it's a mess.
For instance, in the 1970s, it was classified as a mental illness. You know, as Justice Alito brought up in another part of his question, people with Down syndrome were institutionalized. That was considered the standard of care. Mm-hmm. And so, isn't this whole argument that we're having under-inclusive in a way, or beside the point?
Yeah, you know, the viewpoint related question, I think, is really critical. And I think where you're getting a disconnect with a lot of people is there is still amongst a lot of people this sort of sense that if a professional organization says it, then the professional organization really that's their purview, and it's hands off. It's hands off. And I think, you know, this circles back to the point that I said earlier, the history, and this came out in the oral argument, the history of these professional organizations being way off, wildly off, is pretty considerable. And then to sort of come in at this point and say, but now we got it. You know, yeah, if you look through the last 50 years, it's a hot freaking mess. But in the year of our Lord 2025, we are straightened out.
Nothing.
We are wrong about nothing. And so therefore, this very personal, variable, unique interplay, patient by patient, between religion, morality, sexuality, identity, all of these things that are just almost impossibly complex. We're going to walk into that with this really broad definition, and we're going to say, you know, sorry, counselor, who's got a Christian kid, say, who wants to bring their behavior in line with what they think that the Bible is asking them to do, to then have a counselor be like, no, if you want to bring your behavior in line, out of line with what you believe the Bible wants you to do, I'm your person. But if you want to bring it in line with what you believe the Bible wants you to do, which is the most important question in your life, I'm not your person, because the state won't let me do that. Like, let's just get brass tacks about it. I think that's where this thing just crumbles and falls apart, because I think a lot of the argument is sort of relying on this is a settled assertion and determination by the professionals, hands off. That would be sort of the Colorado argument. Licensing professionals have made a considered judgment of what is the medical best treatment. The state is just enforcing that through statute, hands off. And then the slightest inquiry into this in a sort of a real world sense begins to realize that no, this is not nearly that simple. The statute is not nearly that precise. You are really putting the state straight into the middle of these very delicate, difficult, again, conversations. That I can't, it's hard for me to see a world where that doesn't implicate the First Amendment. And you're totally right, Sarah, that there is a difference between, when you're bringing in things like hormone injections, or you're bringing in things like surgery. There are ways in which these determinations about hormone injections and surgery, et cetera, are determined by viewpoints as well. But that the actual physical act of the hormone injection, the actual physical act of the surgery, is just substantially different constitutionally from conversation. And
all right,
that's the core.
All right, when we get back, I'm going to tell you about the best hypothetical from the entire argument from Justice Sotomayor. It involves anorexia. All right, David, Justice Sotomayor comes up with this great hypothetical, I think it's really difficult based on everything that we've said, because it takes it out of the culture war, and it takes it out of what I think we would generally think of as viewpoint discrimination. What if we're talking about licensed therapists with patients with diagnosed anorexia? Can the state tell a therapist that they are not allowed to encourage their patient to further restrict their eating? Right? I mean, everyone would know that if you're talking to a minor child, a young woman who thinks,
right,
young girl.
So a 16-year-old is starving, and they say, eat less.
Yep. She's looking in the mirror and she's like, I'm too fat. And and I think people are like, well, that's ridiculous. Well, let me build it out a little bit here. She's oppositional, right? She's 16 years old. And the more you tell her you're not fat, you need to eat food, blah, 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 the more she's just pushing back and really clinging to this control that she has over her life that she's using eating for. And so instead, as a therapist, you decide, you know what? The best thing we're going to do is go through with her through the darkness, So I'm going to tell her, you know what? I hear you. I see what you're talking about. I get it. You're fat. And you want to restrict your eating. I'm going to help you figure out how to do that in a healthy way. And we're going to restrict your eating together and get through this. Can a state bar a licensed physician from doing that? Or is that viewpoint discrimination as well? I think that's a really hard call, David, because it sure seems to me like a state should be able to tell a licensed therapist, no, of course you cannot tell someone who is suffering from this that, they're fat and should eat less.
Yeah, that's an interesting hypothetical. And I think there's a couple of reasons why the hypothetical, because there's an interesting element that came up in the oral argument, and that was, what about malpractice? What about malpractice? Does malpractice still exist? So if we're going to say there is a First Amendment right implicated here in a practitioner helping someone try to align their behavior with their values, for example, that there's a First Amendment right there. Does malpractice still hold? And the answer from, Chiles was, yeah, absolutely, malpractice still holds. And that's what, those hypotheticals, my first thought was, that's malpractice and that person's going to get sued.
Sure. But why do we have to wait until the harm's already done? I think is what the state would say. We know the standard of care. We know we have lots of data on anorexia. We know that the idea that you can go through the darkness with them isn't going to work. And so we're going to ban it on the front end to protect all these kids. So there's not malpractice, meaning the kids were already harmed.
Yeah, I think I'm just very skeptical of a state statute that is prophylactically interfering into the conversation between a therapist and a patient that is going to walk into that very intimate situation and ban a particular method or tactic of attempting to deal with an underlying condition based on that unique relationship between the therapist and the patient. I'm going to look at a prophylactic statute that's going to be regulating conversation very skeptically. And then you might say, what's a licensing agency for? Well, it's for things like certifying that you have the right education, that you pass criminal background checks, that you uphold codes of ethics, that you these are, all in entirely suitable grounds for a licensing agency to restrict you. And then you do have malpractice. And by the way, it is not the case. It is not the case that malpractice just means that it's all post hoc, none of it's prophylactic. Malpractice judgments have a prophylactic effect, without question. So,
I think that's all right. I agree with you entirely. I just like causing trouble. All right. Let's talk about President Trump's actions in Portland. A federal district judge appointed by President Trump, for what that's worth, told the president, on federalizing the National Guard, either the Oregon National Guard, or when they were like, okay, fine, we'll send in California and Texas National Guard. Not amused. She was not amused with that idea that they tried. But David, they originally tried to do this under Section 12406. We have talked about that before. And this is the unable to execute federal law. And therefore, there's a rebellion or something else going on. The state isn't doing it. You're unable to execute federal law. So you may federalize the National Guard to bring them in. And the judge in this case, very interesting, right? Basically says, look, in the last days or even weeks, there have only been small protests, 20 people, 30 people. The violence has been non-existent or minimal. And therefore, a reasonable person cannot say that you are unable to execute federal law. Therefore, the president is not acting in good faith. And so even though this statute allows him to determine whether he's unable to execute federal law, there's like a good faith presumption, and he couldn't even meet that. So no, you can't federalize the National Guard. Here's what's interesting, David, as Professor Jack Goldsmith, friend of the pod, former professor of the pod host, pointed out. Yeah, but if you go back to June, this Immigration Customs Enforcement Office had to be shut down. It was closed for 3 weeks because the violence had gotten so bad and it had so damaged the building and put officers at risk. They just had to shut the whole thing.
Yeah. It was a security card reader. Yeah.
And people had been, having flashlights. They had been prevented from getting out. There had been all sorts of very, very unlawful, potentially harmful shenanigans. The building gets shut down. They are, at that point, unable to execute federal law effectively. But that's the last 2 weeks of June and the first week in July. There, of course, have been violence at other ICE officers. There was the shooting in Dallas that was obviously tragic, but also very much targeted at ICE. And so the question for the Ninth Circuit and potentially the Supreme Court is going to be, at what broad level does the president get to look? Can he only look at the past few days or weeks, as this judge implied? Or is it sort of in the grand scheme of right now? And I'm going to include June in this, but also what's going on in other parts of the country. So it's like temporal generality and locational generality, and say, that is at that point up to the president's discretion. This is a much more interesting case than the Los Angeles case, where the violence was now there and clear. And the arguments against Trump being able to federalize the National Guard, I thought, were quite weak. It was basically like, well, the violence isn't enough. He's not unable to execute federal law. It's just harder, but it's like way harder. And local police are dealing with this, even if they can't stop it, and it'll be under control shortly. I mean, those were really easy to deal with. You can federalize the National Guard to deal with that. This is a much more interesting legal question. So what do you think? Did the judge get it right? Will the appellate court switch this up? And we'll have to get to the Insurrection Act next, because even if all the judges shut him down on 12406, he's got other tricks in his hat.
Yeah. So, the 12406 argument, it's kind of interesting, Sarah. I have a feeling about 12406 that like excuse me. I had a feeling coffee down the wrong pipe. I had a feeling when I'm thinking about 12406, very similar to how I felt in the birthright citizenship argument or birthright citizenship universal injunction case, that okay, you can do something about universal injunctions, and we should, but immediately there's two or three other ways to accomplish the same thing, whether it's APA injunctions or it is, class action related injunctions. Here, if you strike down a deployment under 12406, Trump can go to the Insurrection Act, where his authority is really exclusively reserved. I mean, it's exclusively, I wrote a piece about this, about calling the Insurrection Act America's most dangerous law.
You're not the only one, right? Jack Goldsmith, Bob Bauer, people from across the legal spectrum have said, and said years ago, flashing red lights. Has anyone looked at this statute? Biden comes into office, Democrats control both the House and the Senate, zero interest in doing anything about this law.
Yeah, I was jumping up and down. I mean, there are multiple failures of IQ tests and that have led to this moment. I mean, just let's be very clear. And this is a big one. So on the one hand, I'm very happy to analyze 12406, but the whole time I'm analyzing it, I'm thinking, well, then
what does
Trump's
it matter?
got the ace.
Yeah.
Yeah, exactly. He has the ace of spades. And so, but let's analyze 12406. I think a couple of things about it. One is 12406, unlike other statutes, doesn't place this explicitly within the discretion of the president. It doesn't say when the president determines. It lays out specific conditions that must exist: invasion, rebellion or danger of rebellion, unable to, with regular forces, to execute the laws. And the way the Ninth Circuit has set this up is we're going to grant the president a lot of deference in this determination, but not absolute, which I think is the right formula, because the statute on its face does not give the president absolute discretion to declare these conditions. So I think that's the right formulation. So then I think there are two questions, Sarah, that are very interesting. One is, what's the time horizon here? So for example, if things are peaceful, but they've not been peaceful in the relatively recent past, is that a condition that should be analyzed? Another is, I do think that the judge is right to do a severity analysis. It's not just say that there was protests or that they even turned violent with or threatening with the flashlights. That just saying that violence exists or a protest exists, is that a rebellion? Is that unable to execute? I think that's a very fair question. And then the other interesting question here, Sarah, is how much is the bad faith of the president a factor in the discretion analysis? And this is where I think this is a very important question. If the president of the United States is saying things that are divorced from reality, that he is saying things that are not true, does that impact the discretion that you grant the president in making the determination? And I would have to say yes. I would say yes, that you're actually dealing with a president who is making statements in the real world that are completely false. Shouldn't that impact how much deference you're going to give a presidential determination? And I think plainly yes.
So there's an interesting consequentialism question here, David. I think on its face, I don't know what the Ninth Circuit will do. It probably depends on the panel. But I think if this got to the Supreme Court, they would say that because of the combination, right, that there was violence here that did make ICE agents unable to execute federal law, that was in recent enough proximity, and with violence at other ICE offices, and the idea that this could erupt in violence, and it's more likely, let's say, than just some random ICE office to erupt in violence. I think they would probably defer to the president on that one, but it's getting to be a really close call. My God, the president being his own worst enemy legally on the Comey prosecution, on this question, it absolutely undermines his case. I don't know that I agree with you on how legally relevant it is. It's there. You can't ignore it. Like it's practically relevant, even if I don't think it should be all that legally relevant. But here's the consequentialism, David, and it's the Insurrection Act. If you uphold the president's ability to do this, life moves on and there's no invocation of the Insurrection Act. If you say he can't, remember this legal scenario is federalizing National Guard. The Insurrection Act allows you to send in the frickin' Marines to do, civilian law enforcement. So it's not only that it's easier to trigger with full deference, basically. The laws don't have to be unable to be executed. Just if it's making it harder to execute the laws in any way, you can bring in the military, they can do civilian law enforcement. And so I could see a judge saying, well, this may be a close call, but also the consequences if it's a reasonable reading either way. So why would I pick the reading that leads to the Insurrection Act?
Yeah, that's a very interesting question. I would say you interpret the law anyway, because
I know
without regard to the Insurrection Act, for some pretty important reasons, which is including this is not the only statute in the federal code that has similar language but does not contain the language from the Insurrection Act, which includes whenever the president considers that, right? Yeah. And so there's a very big value in carving out that there are distinctions between laws that say whenever the president considers and laws that don't say whenever the president considers. That is a super important principle to establish. And then the second part of this is, I think one of the reasons why the Insurrection Act has not been invoked yet, and I think it's almost inevitable that it will be, is that there is a calculation that there's a political cost to invoking the Insurrection Act that may not exist when I'm invoking a plain vanilla 10 USC. I can just say, get on TV and say, Title 10 gives me total discretion. And people believe it and listen to it. Whereas the Insurrection Act, the very word itself, Insurrection Act, communicates that you are declaring Portland to be an active insurrection against the United States of America. It's so at odds, I think, that there's a reason why they have not gone that way. Although I do think that, some of the ICE tactics, I think it's very clear that a lot of what is happening right now is there is very intentional provocation through aggressive use of paintball guns, tear gas, things like this to try to trigger more violent confrontations, which that will then be used. And that's one of the reasons why when I talk to folks, I say, look, the model, if you want to protest, is the civil rights movement, non-violent philosophy. And if the fire hoses and the pepper spray and all of that is going to come on, that's got to come from the state. That's got to be.
And that is not what's happening from these protesters, to be clear. They are putting up agents' photos with their home addresses, trying to shine lasers in their eyes, flashlights in their eyes, trying to block their cars from getting out, destroying the security reader. And that's setting aside the just vandalism, violence, the sort of normal course of violent protests.
Yeah.
By the way, David, it sure looks to me like if we're not at a majority, we're certainly close to a majority of presidents have invoked the Insurrection Act. I mean, Washington, Adams, Jefferson, so our first three presidents all did. Jackson, Lincoln, Grant, Hayes, Cleveland, Wilson, Roosevelt, Eisenhower, of course, sends in, he not only federalizes the National Guard, but also sends troops in to enforce school desegregation. John F. Kennedy, Lyndon B. Johnson, also related to the civil rights movement. And then famously, of course, H.W. Bush uses it, Hurricane Hugo and the Los Angeles riots. So it's interesting. On the one hand, we talk about how dangerous this statute is. And I think we mean that from a legal scenario, right? There's just no guardrails on it.
Yeah.
And
exactly.
History shows us that there's clearly no guardrails on it. But in terms of it actually being dangerous and tyrannical, clearly not, when half the presidents have used it and we don't even really care. And some of these we look at and we're like, thank God Eisenhower sent troops down to Arkansas.
Well, this really points to something, Sarah, that I think is a sort of a very interesting historical question. Did we grow up in a blip in American history? I think I did. so I'm born in 69, 5 years after the Civil Rights Act. I have no memory of the 68 rioting and a wave of assassinations was a year before I was born. I have no memory of Kent State shooting, for example. I have no memory of the wave of bombings across America when I'm 1 and 2 years old. And so I'm growing up in morning in America, followed by the end of the Soviet Union, followed by, so I didn't see the civil rights protests. But if you look at American history is very fractious and has been very fractious at various points for a long time. And so, yeah, it is not at all. Many of those elements that you talked about invoking the Insurrection Act, for example, with HW in California, that was at the request of the governor of California. So that's one where the Insurrection Act is doing sort of, I think, what it's supposed to do. If a governor says, we can't get this done, I need the federal government, that is a classic case where an Insurrection Act would be, deployment would be appropriate. But I think if you look at American history, the Insurrection Act, the deployment of the Insurrection Act is a sign of how fractious we've been. But I think one thing that's very different about the moment is I feel like the president of the United States is the one who's trying to engineer the fractiousness through the use of his federal military authority. So in other words, it's not that the federal military authority is actually here designed to quell as so much as it is designed to trigger. And then in the triggering will permit larger deployment and larger deployment. And so that, to me, that's the very material difference of what's happening here.
And yeah, I mean, just to reiterate the differences between these two statutes. So the statute that Donald Trump is using now is the one that's being litigated, that the Portland judge said no to federalizing the National Guard for the purpose of protecting federal buildings and federal law enforcement officers. If he invokes the Insurrection Act, that's the deployment of regular armed forces. You can send in the Marines if you want. 2, they don't just protect federal law enforcement officers and buildings. They can do civilian law enforcement. They can arrest people. They can go out, if you will. They're on offense, not just defense. And 3, the triggers are silly. Whenever the president considers that unlawful obstructions, combinations, or assemblages make it impracticable to enforce the laws of the United States.
What the heck? What the heck?
So yeah, we can talk about that more, although it is worth noting that Donald Trump threatened to invoke the Insurrection Act in his first term related to the protests around George Floyd, where there was real violence. There certainly was the inability to enforce federal law at the height of some of those in some of those cities, and he did not do it. So we'll see is the answer. David, when we get back, I've got a couple mailbags for you. David, I have some excellent mailbag from listeners, like expert listeners. We won't have time to do them all today, so I'm going to save some of them, but I wanted to bring up 2 with you. One relates to the sentence of Nicholas Roski when we talked about the would-be assassin that showed up at Justice Kavanaugh's house at 1 a.m. and was sentenced to only 8 years, where the judge in that case cited several reasons, many of which were related to, no criminal history, turned himself in, remorseful. But one of those reasons was President Trump's order about transgender treatment in prisons, that Nicholas Roski would be sent to a men's prison. And the judge said he might be unable to receive the treatment that he wants. And I said, yeah, but abuse of discretion is a really, really high bar. It will be very hard for an appellate court to say, like, as long as you had other reasons, that one of your reasons was not okay, may not be enough to send it back, especially, the sentence has to be correctly calculated. That's a yes or no. If it's not calculated correctly under the sentencing guidelines, it goes back no matter what, even if the judge would have departed from it. You have to do that. There's procedural things that you have to do right. But then the judge has discretion. Okay. However, one listener sent me the Capital One hacker, Paige Thompson. This was a person who was sentenced to 5 years of probation plus time served after a hack that was the second largest data breach in the United States at the time, causing tens of millions of dollars in damage and emotional and reputational harm to numerous individuals and entities. This was the Capital One hacker, David, if you remember this incident.
Yeah.
The Ninth Circuit, two judges on the Ninth Circuit said that it was substantially unreasonable because the sentence was so lenient, and the judge had cited the defendant's transgender status, autistic status, had suffered past trauma, and raised the prospect that the Bureau of Prisons' decision under future presidential administrations making life more difficult for transgender inmates, but also noted the hack wasn't done in a, quote, malicious manner, and that Thompson was, quote, tormented about her activities. It actually sounds remarkably similar to this sentencing situation. And there you had a 2-to-1 panel of the Ninth Circuit finding that that was an abuse of discretion. Now, 5 years probation plus time served is different than 8 years in prison. But you know what? So is a hack versus trying to assassinate 3 Supreme Court justices. So thank you for bringing this one to our attention. It does seem awfully on point. Now, it will be a different circuit, so that is not binding precedent for this case, but sure is interesting. And David, you kind of had said that you thought it would meet abuse of discretion.
That it would not meet?
That it would. Yeah.
No, I do think it meets abuse of discretion. Look, I wasn't on the podcast on Monday, so I didn't get to rant. So I'm going to take the opportunity now. Come on. Okay, look, we are in a moment where political violence is a huge problem. And it's not just that it's a huge problem on its own, that in other words, the murders and assassinations and the arson and the threats and the intimidation, they're all independently horrific, okay? But we also have another political violence problem, which is a lot of people are not taking political violence seriously enough, especially if it's committed by somebody that they might have underlying sympathies with their side of the political spectrum, right? And so we have this situation where if it's, let's say you're on the right and somebody who is coming from the right commits an act of political violence, well, they're just crazy. You can't ascribe that to us. They're just crazy. And if it's somebody on the left and they commit political violence, and all of the left is violent. And the same thing happens in reverse. If somebody on the left commits political violence, first there's denial, can possibly be. And then it's like all the 5 stages, denial, bargaining, angel, and so no, and then it's, well, bargaining, they're not really on the left. They're just crazy. Both sides do this. And every time I say the word both sides, some small number of people online burst into flames, but it is true. It is true. And if you are minimizing political violence, including by light sentencing somebody who tried to murder a Supreme Court justice, this is a problem. It's a problem. And so this sentence is absurd, especially in a backdrop of escalating threats against judges. It looks like, based on at least some very preliminary stuff, what I've seen, there was a judge whose home was burned in South Carolina. It does not appear at the moment that it was arson, but it's very sad that one of the first thoughts that happens when you see a judge with a house fire, that's like front of mind. 15 years ago, when a judge has a house fire, the first thing I think is, oh man, that's a shame. Somebody must have left a candle burning. Now, the first thought that happens when I see a judge with a house fire is, oh crap, did somebody set that? And like, we're in this mode where we have heightened awareness of, for good reasons, of political violence, combined with heightened rationalizations of it, depending on who's doing it. And this does not help. This is one of the areas where I hope that the judges are human too, would mean that, look, if we have light sentences for someone who tried to kill a SCOTUS justice, that's a problem for all of us on this court. That's a problem. So, okay, rant over.
As I said, it's going to be really hard for people to complain about threats to judges if you're not willing to complain about this sentence. right?
I mean,
What do you actually want to
compli-
have done about threats against judges, if not sentence the people who do it to prison?
the guy went to Kavanaugh's house armed to the teeth.
Yep.
I mean,
Yep.
come on.
All right, David, the next email we got, I actually had been stewing on this. Do you remember when we talked about that case in our term preview about how everyone wants to get to federal court and like there's all these cases about how to get to federal court? And I was trying to explain to our listeners, like, why is it that everyone wants to go to federal court? And I felt like I didn't have a particularly good explanation, and that B, the explanation I gave kind of threw a lot of shade at state court judges. So we heard from a state court judge, and I'm so glad we did. And I just want to read some of this email. First of all, as she notes, like, the numbers aren't even close. As friend of the pod Judge Jeff Sutton highlights in Who Decides, state courts are where the action is. In 2017, there were 17.4 million criminal cases in state courts. Federal courts, 82,000. Whoa. Overall, that same year, there were 83 million cases against in state courts against 359,000 in federal court. I mean, yeah, just percentages.
Yeah.
That's, I will grant you that sort of, I knew that, and yet it's still stunning to say out loud. The numbers tell the story. State courts are the main engines and drivers of the nation's judicial system. If our state courts were so demonstrably inferior to their federal counterparts, what would this say about our judicial system overall? I don't believe that they are, so I can still hold a high regard for how justice is decided and delivered in this nation, all things considered. Totally correct. And an excellent point. So why is it, David, that everyone's trying to get into federal court? She argues, and again, I think I'm pretty persuaded by this, it is not that the state court judges are corrupt partisan morons, as I didn't say, but definitely implied. But here are some of the reasons that she notes. It's easier to get pro hoc vice status in federal district court. Many lawyers who sort of do that sort of thing are already very familiar with the federal rules of civil procedure and don't want to bop into some state that they've never lived in and don't know the rules, and they don't want to hire local counsel. It's going to cost their client a ton of money. Federal courts obviously have a lot less work to do, so they move faster and they prioritize your case better, which is pretty circular. Federal courts have more resources, especially at the trial level. When I think about my court in comparable terms of the number of law clerks, research attorneys per judge to those of the Court of Appeals, the Federal Court of Appeals, the circuit court where I am, at the trial court levels, federal district judges most definitely have more research help than do our trial judges. I guess my point is not so much that there aren't valid reasons for wanting to be in federal court over a particular state court, but more simply that those reasons depend more on institutional incentives and resources and less on bench quality. I think that's exactly right, David, and a far more helpful explanation than the one that I gave.
I think that was a great explanation. It's funny, as soon as you said that, I knew you were going to get incoming email. And I was like, we didn't have a chance to fully amplify. Yeah. Well, we didn't have a chance to really fully amplify. And coming from the standpoint of practicing for 21 years before I did this journalism thing, I was in a position where I wanted to be in state court and where I didn't want to be in state court. Mm-hmm. And it was super context specific. So let me tell you some of the calculus that I used. Now, when I was practicing constitutional law, we were always wanting to be in federal court. That these are the judges who had the existing, the existing sort of, to greater or lesser degrees, background that this is the stuff that federal courts do, is handle matters of federal constitutional law. So if I'm in a con law case, I'm filing in federal court. And if I tried to file in state court, the defendant would remove to federal court. So it'd be federal question jurisdiction. And so on constitutional cases, federal court. But let's look at commercial litigation. When I was in a plaintiff side in commercial litigation, I wanted state court. Why? The jury pool difference. This is not related to the this was not related to the judge so much as it was related to the jury pool. If I am in state court, and let's take a real world case, I was suing on behalf of a local company in a town called Prestonsburg, Kentucky, okay, that had lost, in our view, millions of dollars from a breach of contract case involving an an out-of-county company, another Kentucky company. So it was not diversity jurisdiction. And so we wanted to be in Prestonsburg, Kentucky. It was and we wanted a Prestonsburg jury. They didn't want to be in Prestonsburg. If they could, they wanted to be in the Eastern District of Kentucky, because then you're going to draw jurors from the whole Eastern District, which would include, guess what? Their town where they are located. Okay. And so that is not a quality of judge issue. That is a tactical consideration as a trial lawyer, and which forum is going to be more hospitable to my case. And so similarly, when we were on the defense side, in some cases in Eastern Kentucky, by golly, we were trying to remove that case to district court, to federal district court. And that's not, in neither one of those instances is it a reflection on the judge. It's a reflection on the jury pool. And by the way, having an Eastern District of Kentucky jury pool or a local county jury pool is not this, again, sort of saying, oh, it's better if I'm pulling it out of the local community where it's happening. No, that's your tactical consideration. It's not empirically better for justice. And so I think that a lot of the gamesmanship that occurs between state and federal courts, brass tacks is about con law, jury pools, and also complex commercial litigation that requires large-scale judicial time investment is more difficult in state court because they also are dealing with the volume of other cases that you just went through. So if it's big, complex commercial litigation, there's just a sense that the case is going to get the attention it deserves in the court with the lower workload. And so other than that, I mean, I have known some just tremendous state court judges that are, when I was practicing in Lexington, Kentucky in the 1990s, as a rule, like our local state court judges were just really impressive people, just very, very impressive. And a number of them I would have rather been in front of than some of, not all of, but some of the district judges, the federal district judges. And so it's just not the case that there is one system is clearly superior. They're just very, very different. And tactical considerations will play.
It might depend which state you come from and the way that state judges are selected, because that can vary widely, and therefore the quality of the judges can vary widely depending on that selection method. And so, that may change one's perspective and how one grew up.
Yeah.
So David, it was my turn in the barrel this time. I'm the one who said the stupid stuff about state courts. But next time...
is it my turn now?
It's going to be your turn in the barrel next time, because I have an email that you're going to want to know about. Basically, here's my headline for it. The spoil system wasn't all bad.
I'm ready for this conversation.
All right.
I'm ready for this one.
On Advisory Opinions.
I love it. I'm so ready for this.